Hey guys, welcome to part 8 of our video series where we're going through the FDCPA. And the last couple of videos we have looked at Section D, 1692D, which is harassing type conduct, and then 1692E, which is deceptive conduct. And now we're turning to 1692F, which is unfair practices. And so let's look at just the general rule first, and then we'll look at the examples. So it says a debt collector may not use unfair or unconscionable means to collect or attempt to collect any debt. Now that'll sound very familiar to you. The language of this statute is meant to be very broad, and it's meant to not only regulate debt collectors when they actually collect, but when they attempt to collect. And so what does it mean, unfair, unconscionable? Well, the simple answer is it just means when they're doing something that strikes you in your gut as that is just wrong. That is completely unfair to do that. And again, this is worded very broadly because when they wrote this statute, they did not know what the next type of unfair action would be, unfair debt collection would be by debt collectors that are willing to break the law. And so they purposely word this very broadly. And then they give us some examples. So let's look at these examples. And the first one is very, very common. And then the next three, we don't really see much anymore, but that's more of just a change in the way that we pay bills. So let's look at number one here. It says the collection of any amount unless such amount is expressly authorized by the agreement creating the debt or permitted by law. And then if we look at that parenthetical, when it says any amount, well, any means any, but it gives us some examples. Interest, fee, charge, expense. It's just anything related to this debt. And so when a debt collector is collecting a debt and they're adding interest or fee or a charge or an expense, we have to say, okay, is that expressly authorized by the agreement creating the debt? So if it's a credit card, is that in the credit card agreement? If it's a car loan, is that in the car loan agreement? If it's a signature loan, is that in the signature loan? I mean, you get the idea here. Or is it permitted by law? Because if it's not permitted by law and it's not expressly authorized by the agreement creating the debt, then that would be unfair. Now, a debt collector may say, well, I don't think it's unfair to add attorney's fees to collecting this debt or a collection fee to collecting this debt. I think we ought to be allowed to do that. Okay. Well, and I practice in Alabama, so does Alabama law allow you to add a collection fee? Well, there's nothing I know of specifically that says, you are allowed to add collection fees. So then we look at the agreement. Well, maybe the agreement doesn't say that. It's got to expressly authorize it, or this is unfair. And where it comes up a lot is with interest and with fees. And then even with charges. So maybe the law does not allow a extra charge if you're paying it by phone. And the agreement may not allow that. Well, then it's wrong for the debt collector to do that. So now the next three, so this would be subsection 2, 3, and 4, these are really talking about post-dated checks. Now, I know we don't really use checks anymore, but the idea of this is the collector would say, hey, you need to pay this, and you say, well, look, I don't have any money in my account. And they say, okay, well, when do you get paid? And so I'm recording this on July 15. So let's say that I tell the collector, well, I get paid on the 20th of the month. They go, okay, well, go ahead and write us a check and date it for the 25th, and I will hold it until then. Now, what happens if I do that and they deposit it 2 days from now when they get it? Well, that would be deceptive. So we go back to the previous videos about 1692E, they lied to me. Well, it would also be unfair because look at subsection 2. The acceptance by a debt collector from any person of a check post-dated by more than 5 days unless such person is notified in writing of the intent to deposit such check not more than 10 nor less than 3 business days prior to such deposit. In other words, if they get you to post-date a check 30 days from now, They can't just immediately send you a letter that says, oh, by the way, we're going to deposit this 30 days from now, because that would be more than 10 business days. But they also can't send you a letter the day before they do it, because they have to give you at least 3 business days. Well, subsection 3 says the solicitation by a debt collector of any post-dated check for the purpose of threatening or instituting criminal prosecution. So they get a post-dated check from you, and then they immediately deposit it, and it bounces, and they say, hey, I'm going to, have you prosecuted for writing a bad check. Or they tell you that's what they're going to do. They say, look, you wrote us a check, and it's not any good, and so if you don't pay us more money now, I'm going to have you prosecuted. Well, that would violate this because it's unfair. I mean, if we take a step back, this law is saying don't do anything that's unfair. Well, subsection 1, if you're adding money, charges that you're not allowed to add, how would you describe that? Fair or unfair? It's unfair. What about if you lie to somebody about a post-dated check? Or maybe when you agree to accept it and deposit it, you tell the truth, then you change your mind, you deposit it quicker, or you don't give the consumer warning. Well, that's unfair. Or number 3, you request a post-dated check to then use that as some kind of blackmail against it. Well, that's unfair. Number 4, depositing or threatening to deposit any post-dated check prior to the date on such check. So I write a post-dated check for July 25th, and they deposit it on the 23rd. That's unfair. How about they call me and say, we're going to deposit it on the 20th? Well, that's unfair because I wrote it for the 25th. They accepted it for the 25th. Now, this next slide will have the rest of these subsections. And these are not really talking about post-dated checks. But number 5 says causing charges to be made to any person for communications by concealment of the true purpose of the communication. Such charges include, but are not limited to, collect telephone calls and telegram fees. All right, so if you're under a certain age, you may say, what in the world is a collect telephone call? Well, that's where if you were, this is long before cell phones, if you were somewhere and you didn't have enough money to make the phone call at a payphone, for example, or maybe you're at a business or a friend's house and, long distance calls are very expensive, you could make a collect call. And so let's say you're calling your parents and your parents would answer the phone and the operator would say, hey, I have a collect call from Bob, your son. And if they agreed to it, then they would be charged for the call. And so collectors could call and say, hey, this is your son, or this is your mom, or this is your sibling, and you accept the call, and then it's really the debt collector. Well, now you're being charged for it, and they lied to you. So again, that would violate 1692E, right? Because they're doing something deceptive. But also is unfair to charge you for a call, and the way they got you to agree to pay for it is to lie to you. Well, again, we don't really see that now, but there can be some equivalent in some type of communication, maybe that we have now, or we'll have 5 years from now, or 10 years from now, where they can end up sticking you with a bill, and it's a way to trick you into talking to them and being charged for it. Number 6 is probably the most common one that at least we use, besides subsection 1. So remember, subsection 1 is collecting any amount that's not authorized or legal. Number 6 is taking or threatening to take any non-judicial action to affect dispossession or disablement of property. So non-judicial means we're not talking about they get a judgment and the court allows them to take the property, or they do a judicial foreclosure action in Florida, for example. That's how you do foreclosures in Florida, is you file a lawsuit and the judge says, yes, sell this property. Well, that would not be non-judicial. Instead, it's judicial. But this would be talking about, for example, in Alabama, the way we do foreclosures is a non-judicial foreclosure. So there's no judge involved in it. Or repossession. They don't go to the judge and say, hey, can we repossess this car? No, they just take your car at 2 a.m. So they cannot take your property or threaten to take your property if, look at A, there's no present right to possession of the property. So if they don't have the right to do this, then to threaten it would be unfair, and actually take your property would be unfair. So in a foreclosure context, let's say they haven't taken the steps necessary to be able to foreclose on your property. Well, then to threaten it or to actually do it could potentially violate this law. Same thing with repossession of your car. So let's say you're current on your payments, but this debt collector says, no, we're going to take your car anyway. Well, that would be unfair. Look at B. There's no present intention to take possession of the property. Again, this will be a theme that you've seen before. When a debt collector threatens to do something, if they really do not mean to do it, that violates the law. Or if they mean to do it and it is illegal, that violates the law. So if they take or threaten to take your property and they have no intention to do it, well, then that would violate the law. So we're really talking about a threat there. They say, hey, we're going to come take your car, or we're going to come pick up the couch that you financed or that you used to secure this financing. And they really have no intention of doing that. Well, then that would violate the law. Or subsection C, the property is exempt by law. So again, that goes back very similar to A. There's no right to possess this property. But this is really saying there can be some things, and we might think of it in a garnishment context. Social Security benefits cannot typically be garnished. So there's no right to do it, and the law says it's exempt. So if you ever have a debt collector that's threatening to take something of yours, property, it could be personal property, real property, whatever it is, you look at this and say, well, do they have the present right to that possession? And do they have the present intention of doing it? And is the property exempt? Because if any of those are true, then that is illegal, that is unfair. Now, number 7, again, we don't really see this very often, but you could think of some equivalents. Communicating with the consumer regarding a debt by postcard. So they send a postcard. Well, the mailman would see that and see, Portfolio Recovery is collecting this debt. Well, that's unfair. Well, what would be the equivalent? Well, maybe posting something on Facebook in a public manner that anybody or any of your friends or whatever your privacy setting is could read that. How about putting something on Twitter? Again, same thing. So sometimes these sections of the law, they don't really apply anymore, and then new technology or new practices come into play. And it's really the principle, because remember, number 7 is not literally limited to just a postcard. It's saying this is an example of unfair, unconscionable conduct that's prohibited by 1692F. It's just an example. So then number 8, using any language or symbol other than the debt collector's address on any envelope when communicating with the consumer using the mail or by telegram, except that a debt collector may use his business name if such name does not indicate he's in the debt collection business. So, we might think of Midland Funding, Midland Credit Management. Well, that doesn't tell somebody that this is a debt collector just by the name. Now, if the name was Midland Debt Collection, well, that certainly would. Portfolio Recovery. Starting to get closer, but it probably doesn't violate this. And generally, we don't see this being done. But again, there could be a practice where they start putting on the envelope, hey, you're a deadbeat. There was a case a long time ago, slightly different than this, but it'll just give you a flavor, where somebody owed child support, and so the debt collector mailed wanted posters, like the Old West, wanted, dead or alive, wanted posters that had this guy's picture, his name, how much he owed. It said this guy's a deadbeat dad. He spends money on himself, not his kids, and they mailed that to the dad and to neighbors. Okay, well, that would be unfair. Okay, now it would violate a whole bunch of sections. Okay, go back to 1692C. Remember, how you communicate with third parties. We back up to 1692B, which is getting location information. No, they weren't getting location information. And then, D, is that harassing? Yeah, I'd say it's pretty harassing. It may not be deceptive, depending on exactly what they said, which would be 1692E, but 1692F, that's the same as a postcard. Except it's a whole lot worse than a postcard. So the point is we use these examples to give us a feel, a flavor for what the actual section means. And so 1692F is something just strikes you as it's unfair, it's unconscionable, which just means outrageous. Then you need to look at these subsections and say, well, can I fit what they did into one of these subsections? And if you can, then you're usually in pretty good shape. And of course, we always want to check the case law. The case law means decisions that judges have made about applying different sections and subsections of the FDCPA. And then that can give us, again, a good idea of what's going on. So glad that you are sticking with us through this long series. And we will now turn to 1692G, which has a lot of application. And then after that, there's a number of sections after that, some of which are important and some not so important for us. But if you have any questions or comments, put those below. My phone number, 205-879-2447, or go to alabamaconsumer.com. And thanks for watching this video, and I will see you guys in the next one. Okay, bye-bye.